Hi friends, I am Naavi from Naavi Academy. Today, the 25th of October 2024, we would like to have a brief discussion on a Supreme Court ruling which was published yesterday on live law. The article actually said Aadhaar card not suitable as proof of date of birth, says Supreme Court. Now, this title actually has raised an issue in the DPDPA compliance ecosystem because one of the requirements of DPDPA is that the data principals who are minors need to be identified and they need to provide consent through their guardians. Subsequently, there are restrictions on behavioral monitoring and targeted advertising to this class of data principals. The same kind of rules also apply to the disabled persons who are represented by legal guardians. Minors are often represented by natural guardians, who is the father or the mother. So the consent has to be given by the father or the mother. In the past, we have been discussing this, and it has been one of the views of FDPPI and myself, and which has been also associated with the DGPSI framework, is that there can be a system developed depending upon Aadhaar records to identify whether a person is a minor or not. And if he is a minor, we can also use the same Aadhaar data for the purpose of identifying the guardian. Now, this age gating process for certain sites has been in discussion, and many of the people in the industry have represented to the ministry that it is difficult to have an age gating solution. And in that context, we also said that UIDAI can be a source from which this can be achieved. There are multiple ways by which this can be achieved, which we presented earlier. One was that a query-based approach where after collecting the date of birth of a person, or say a declaration that I am not a minor, a reference is made to the Aadhaar data to check the date of birth, so that, and through a query, that is, Aadhaar was originally envisaged, was supposed to be a query-based database, which means that if I say, is this the date of birth of so and so, then the reply should come yes or no. I will be giving date of birth along with the name, and that combination is what the Aadhaar database is confirming. This was the original principle under which Aadhaar was developed. And subsequently, to avoid the disclosure of the Aadhaar number, UIDAI has also introduced virtual Aadhaar IDs so that a person, without disclosing his original Aadhaar ID, can provide his virtual Aadhaar ID to a data fiduciary along with the demographic details, which can be verified by a reference from the data fiduciary to UIDAI. And he will get back yes or no responses. Now, this is one system by which the age of a data principal can be verified. The second way it can be done is there can be a specialized consent manager who specializes in providing consent for and on behalf of minors. Just as we have KYC players, there is know your customer players, we can create a new system for know your minor kind of a query, and the service provider can take steps to identify a person, whether he is a minor or not a minor, by referring to UIDA database, or also to other databases such as the uh, passport, or say driving license or any other document. This was something which we had suggested. In the light of this, when this report came that Supreme Court has considered Aadhaar card as not a proof of date of birth, obviously there is a concern. The concern is that this title of the article is misleading, and it does not affect the recommendations of DGPSI earlier to use Aadhaar-based underlying system for age verification. The reason is that this particular case, which is actually a case of an insurance claim in the case of an accident. In this particular case, a claim was preferred on behalf of a deceased person, and the compensation was worked out based on his employment information and the salary or the income he would have had in case he had not unfortunately passed away in the accident. So when this calculation was done, the lower courts had used certain measures of the labor law and arrived at something like how many years of service the person had. Therefore, what should be the compensation payable as a multiple of the number of years of service undergone or something of that nature. So the date of birth of the deceased was relevant for the purpose of the calculation of the compensation. The lower courts had used the Aadhaar date of birth and arrived at a certain compensation. Subsequently, the insurance company made an appeal to the Supreme Court, stating first to the High Court, of course, then to the Supreme Court it has come, wherein the insurance company took a stand that the date of birth of the person in the Aadhaar and the school leaving certificate are different, and therefore the particular calculation of the compensation was not accurate. In fact, the lower court had taken the school leaving certificate as the basis, not the Aadhaar, and the Aadhaar date was slightly different. Okay, so the matter was discussed in the Supreme Court, and in this context, they had two documents which spoke of the date of birth of the same individual, and the court had to take a decision which is a better document. And if they had taken the school leaving certificate, the compensation would have been some X amount, whereas if they had taken the Aadhaar based evaluation, the compensation would have been lesser. It would have been beneficial to the insurance company, but not to the consumer. So the court took a consumer-oriented decision in this context and said that we will go by the school leaving certificate, and therefore the appeal is dismissed. There is no need to change the lower court verdict. Now, this should not be interpreted as Supreme Court rejecting Aadhaar database for the purpose of identifying the date of birth. This was a peculiar situation when alternative documents were available. They were in conflict, and one would have favored the consumer, another would have favored the industry. And the Supreme Court finally took a decision in favor of the consumer. I think we should leave the interpretation just as that in this context, when multiple documents were there for date of birth, then in the context, the school certificate, school leaving certificate was used as a more reliable document than the Aadhaar. But when we come to the privacy domain and DPDPA domain, we are talking of a data fiduciary who is not having all the resources of a court to decide about the date of birth of an individual by making reference to multiple documents. He needs some reliable document which not only identifies the date of birth, but it also should identify who is the guardian of the particular minor, so that they can go and take the consent of the guardian. Now, there are not many documents officially from the government which can provide both the date of birth of an individual and who is his guardian in case the subject is a minor. Aadhaar is one document which has this provision. So the Aadhaar which is issued to a minor has the date of birth as well as the guardian's name. This date of birth is important because after some time, when the minor attains majority, the consent given by the guardian actually has to be switched back, and a new consent has to be taken by the erstwhile minor. So therefore, it is not enough if we have a identification of a person as minor or not minor. If he is a minor, we have to actually get the date of birth so that we can diarize the date of him attaining majority and switch the consent. Also, if he is a minor, we need to know who is the guardian so that we take the guardian's consent, which will expire on the minor attaining majority. So, we feel that the data fiduciaries should continue to use the Aadhaar-based system in a manner in which it does not violate the privacy of a person by either collecting the virtual Aadhaar ID only, not the full Aadhaar ID, or using the services of a consent manager for this minor verification, who in turn should take responsibility to ensure that there is no violation of the privacy norms of the minor. So we are taking a stand that the earlier guidance, DGPSI guidance, as far as the minor is concerned, stands. In case necessary, particularly as a consent manager, if the consent manager for this purpose who does this KYM, that is know your minor kind of evaluation, he is open to refer to more than one document like Aadhaar, in addition to Aadhaar, a passport or driving license or the school leaving certificate. He can use multiple documents, and he may even take a stand that if there is a discrepancy, then perhaps he will ask the person to justify through a court order or some other assurance by which he can confirm what should be the date of birth which should be taken for the purpose of recording the data principal's consent. So we would like to summarize the Supreme Court judgment saying that it is fine. We do accept that in this particular case, the Supreme Court has preferred the school leaving certificate over Aadhaar for the purpose of determining the age, but this is not necessary to be considered as a universal jurisprudence. The jurisprudence is that the data fiduciary shall take such reasonable steps as may be necessary to identify whether a data principal is a minor or not a minor, and if he is a minor, will take such reasonable steps as are required to note down his date of birth and the name of the guardian, and therefore thereafter diarise and ensure that on or after the person attaining majority, the consent which is presently taken from the guardian is switched back to the erstwhile minor. Thank you for listening to this broadcast. We will come with more such uh, pieces as we go along. Thank you.